Good afternoon. My name is Philip Munoz. I'm the Tocqueville Associate Professor of Political Science and Concurrent Professor of Law here at the University of Notre Dame. I also have the privilege of directing our Constitutional Studies program as co-sponsoring today's event with Notre Dame's Federalist Society. Just a word about our debate today. We will use the raise hand function. We have a small group here gathered together to watch in person. But for those who are online, you can use the raise hand function to ask questions after our speakers have a chance to speak. We're co-sponsoring today's event with Notre Dame's Federalist Society, and it's my pleasure to introduce the president of the Federalist Society, Ali Howe, 2L, right?
3L.
3L now, 3L Hillsdale undergraduate, and 3L here at Notre Dame Law School. Ali?
All right. Thank you so much, Professor Munoz and the Con Studies program for co-sponsoring this event with us. And I'm excited to introduce our faculty and our moderator today. So Professor Yu is the Emanuel S. Heller Professor of Law and Director of the Korea Law Center, California Constitution Center, and Berkeley Law School's Program in Public Law and Policy. His most recent book is Defender-in-Chief, Donald Trump's Fight for Presidential Power. Professor Yu received his JD from Yale Law School and clerked for Justice Clarence Thomas on the Supreme Court and Judge Lawrence H. Silberman on the U.S. Court of Appeals for the D.C. Circuit. And Professor Prakash is the James Monroe Distinguished Professor of Law at the University of Virginia Law School. His most recent book is The Living Presidency, an Originalist Argument Against Its Ever-Expanding Powers. Professor Prakash also received his JD from Yale Law and clerked for Justice Thomas and Judge Silberman. And finally, our moderator today is Dean Reuter. He's the General Counsel, Vice President, and Director of Practice Groups of the Federalist Society, and he received his JD from the University of Maryland Law School.
I guess I'll go first. It's a great pleasure to speak here at Notre Dame. I'm sure it's soon to be renamed the Amy Coney Barrett School of Law and University. Both Sai and I, we have very similar careers. And also had we both clerked for Judge Lawrence Silberman in the DC Circuit, and then we clerked for Clarence Thomas. In that capacity, I think we both had the pleasure of meeting Judge Barrett because she clerked for Judge Silberman as well. So I think I've probably known her since she was 26 years old, maybe 25 years old. And we have a lot of stories to tell during the Q&A for all the reporters out there who are already digging up dirt for her confirmation hearings. But this debate is also great because it's great to be here with Phil Munoz, who's done, I think, such a great job building the program there at Notre Dame. And this is, I've never seen this happen before. Phil sitting at the back of the room, his mouth covered silently, not speaking. So I'm going to take advantage as much as I can of this wonderful opportunity of Munoz's silence, which will not last for long, I am sure. The other thing I say is it's great to be here with Sai. Sai and I actually spent a whole year together clerking at the Supreme Court for Justice Thomas, and you don't get your own office there. You may not know this, but you actually share an office for the whole year. And I spent the whole year arguing with Sai, and as you're going to see in this debate, he is so obstinate. He never changes his mind. For a whole year, I kept trying to persuade him from everything from big issues to little issues. I can't remember a single time he ever changed his mind. So we're going to give it another try, see if we can change his mind this time. So let me start out by saying up front, 4 years ago, I wasn't on the Trump train. I wasn't the supporter of President Trump's. I actually was quite worried about him, and especially about the Constitution, because President Trump's a populist. And populists often dislike the Constitution. They don't like restraints on their power. They want to fulfill the mandate that they feel they are carrying on behalf of the voters. And they often strain against, or even campaign against, the status quo and the normal way of doing things. And I think that's a good way to describe what a Constitution is. The Constitution is there to, in many ways, to create and keep in place a status quo. However, and also let me say, I think this has been a consistent worry about the Trump presidency throughout the last 4 years, culminating, of course, I think, in this January's impeachment. It's hard to believe it's just a few months ago, but we actually, our political system was wrapped up in the process of an impeachment of a president for exactly doing what is the subject of this talk. Did the president abuse his executive powers? You may remember Nancy Pelosi said, we have to impeach this president because he thinks he's a king. However, at the end of 4 years, I am actually left thinking, unintentionally or not, consciously or not, Trump has been defending the Constitution. He's, in a way, many ways, compared to 4 years ago, the most unlikely supporter of the Constitution. Look at what is going on right now. We have a Supreme Court vacancy. I can't speak for Sai, but I do hope that our country, for the first time, will correct its errors and finally put someone from Notre Dame on the Supreme Court. I mean, it's time. I mean, not everybody has to go to Harvard and Yale, right? President Trump is trying to fill that seat by following the Constitution. The Constitution says the president can nominate justice to the Supreme Court. It doesn't say that that power ends in any certain time period before his term is over. The Senate has the constitutional power to give its advice and consent. That's actually where, and we could talk about this later, that's where I think actually all the political and constitutional action is going to be about this seat, is not really the White House, it's going to be in the Senate. But Trump's not the one who said when he came into office in 2017 with the Republicans controlling the House and the Senate too, let's really take control of the Supreme Court and add 6 seats to the Supreme Court and vastly expand the lower courts too. That's actually Trump's opponents. Similarly, it's Trump's opponents, not Trump, who've said, let's get rid of that electoral college. This, antiquated hangover from the days of slavery, which only produces racist results. It's not Trump, it's his opponents who I think want to create, make permanent an unconstitutional entity, a permanent independent counsel, which will have the right to use the criminal laws to intervene in our political disputes. That's not Trump, it's his opponents who want to expand the powers of the federal government into control of the energy sector, the transportation sector, the housing sectors in ways I think run quite contrary to the limits on federal power and the role of the states in our system. I think what the story, the argument in my book, and I think the story of the last few years has been that Trump has so enraged his opponents because he's a disruptive force politically, without a doubt. Because of all his ethical issues, all the political issues, all the drama, that his opponents have gone and sought the change of constitutional norms, practices, and traditions in order to bring him down. And in fact, Trump has tried to restore constitutional values, and mostly by playing defense, mostly by trying to defend the legitimacy of his presidency. So let me give 2 examples here. One is of course, the Russia collusion investigation. You may recall President Trump fired Jim Comey as head of the FBI, set off claims of obstruction of justice, led to the appointment of a special counsel, Robert Mueller, who in the end cleared Trump of the Trump campaign of collusion with Russia, but left open the question whether the obstruction of justice had occurred. To me, if you step back and look at what that meant constitutionally, you had, I think, an attack on Trump from a permanent bureaucracy, a bureaucracy that thinks it knows better than the political system who's fit to be president, that makes the claim of independent, apolitical, neutral, professional, or technical, or scientific judgment, and that should be superior to the output of the political system. And you could see Trump, by firing Comey, by reasserting the right of the president to control the personnel and the agenda of the executive branch, Trump was trying to restore a kind of 18th century constitution where we, the people, elect people to office. We choose the president, and that president, who is responsible to us, controls the bureaucracy. And you could see the claims of a Comey or a Mueller or the law enforcement bureaucracy. This claim that they have this kind of technical, nonpartisan judgment and expertise as a 20th century constitution, one created really by Woodrow Wilson intellectually, that claims that all the problems of government can be reduced to scientific questions. And what we want is not a government that's under the control of politics, as in the 18th century, as in our original constitution, but a government that's freed from politics, that's insulated from politics. And I think that's really what that was about, was you had a rise of the law enforcement bureaucracy against this unorthodox, disruptive, but political president. And Trump had to fire them, had to fight with them in order to fight for the original Constitution. I'd also say impeachment has a similar flavor to it. Here you have, again, a disruptive president who does not agree with the establishment on foreign policy, on the way to conduct diplomacy, completely unorthodox in his ways. And you have, again, another independent bureaucracy, this time the Foreign Service, that also believes in its expertise and scientific judgment. You may recall in the impeachment process, people said over and over again, Trump, he wouldn't wait, he wouldn't listen to the interagency process, as if this were this was the forgotten 11th commandment Moses left behind, the interagency process. He forgot to list it along with the other 10 commandments. It's so important to the bureaucracy. But instead, Trump wanted to say, I'm in charge of foreign policy. I get to decide the foreign policy of the United States, and I get to conduct diplomacy. In both cases, again, Trump is making the claim of the 18th century Constitution. The president is the only constitutionally recognized officer who exercises the executive power, who enforces the law. Everyone underneath the president is an assistant to the chief executive in order to carry out those constitutional duties. And again, like the FBI and the CIA with collusion, here you have the Foreign Service fighting against that notion, fighting instead for the idea that they have independent, superior judgment to the political process. So I think mostly what Trump has done in his presidency actually has to use his constitutional powers in this very defensive way as a shield from these attacks on the legitimacy of his election and the legitimacy of his office. A lot of the other things people complain about are primarily areas where Congress has given vast powers to the executive branch. And Trump has really relied on very traditional arguments and claims that past presidents have made in order to exercise them. For example, like building a wall at the border. He didn't say he had the constitutional authority to build the wall by himself. If he did, I would think that's a violation of Article 1, Section 8. But instead, he said there's a national emergency statute. If I declare a national emergency, I'm allowed to move money between different spending accounts in the Defense Department and move it from military bases to a border wall. I actually don't think there was anything really extraordinary about that. Politically, yes, politically disruptive. Constitutionally, pretty standard. I think the major area where Sai and I are going to disagree is in the area of foreign affairs. And here again, it's really interesting. Sai and I have debated and argued before about whether the president can start hostilities abroad without Congress, or whether Congress, because it's declared war power, has to give its permission first. I think the president can go ahead, and that the main check is Congress's power of the purse and power of the military. Notice what Trump has done, though. He's made these claims, very broad claims of constitutional power, but in the opposite direction as a matter of policy, which makes his actions, again, almost sort of defensive in nature. He hasn't been starting new wars. He's been wrapping them up. He's been pulling troops out of Syria, out of Iraq. He's thinking about pulling them out of Afghanistan. He wants to reduce the troop presences in Europe and Asia. If Congress really is in charge, why can't Congress make them all stay there? Why can't Congress stop why isn't the president just reduced to carrying out Congress's wishes? Congress, this isn't happening long, and Congress is much more warlike these days than the president. The president has also been terminating agreements left and right, the Iran nuclear deal, the Trans-Pacific Partnership, the Paris Accords on global warming, several arms control agreements with the Soviet Union. Again, the fight used to be Congress being upset that they've been left out when the president makes new deals. But again, Trump is using his executive power to reduce the footprint of the United States around the world. If Congress were really in charge, why can't they make us stay in those agreements even if the president doesn't want to? And then the other main area we talk about is the Supreme Court appointments. I'd be very happy to talk about those in more detail in the Q&A, but of course, I think Trump, maybe his longest term effect on the Constitution, I think everyone's talking about that now, is if he does get to appoint 3 originalist justices to the Supreme Court, he may set the court on a conservative direction for a generation. And that, in the end, may be his most important effect on the Constitution. So thanks a lot for bearing with me. I'd love to hear Sai and have the opportunity to respond to him and the opportunity to respond to all of you in the question and answers period. Thanks very much.
All right. Well, thanks so much, John. Thanks so much, Phil. Thanks to the Notre Dame Federalist Society, and thanks to Dean for all making this possible. It's great to be virtually with Phil. Phil and I were fellows at Princeton almost, I don't know, 2 decades ago. I don't know when it was. It seems a while ago, and we had a great time getting to know each other. It was a wonderful experience for me, and I think it was for Phil as well. And then John, as John said, I've been friends with John for more than 20 years now. And we've co-authored a thing or two, and it's fun to be on a Zoom call with John. What you see from John is the way John is all the time. He's an hilarious guy and full of good jokes. So I think my book complements John, and this is the book, right? Operators Are Standing By. It's available on Amazon at your local bookstores. John's book focuses on President Trump, but of course talks about presidential powers more generally. My book doesn't talk about President Trump very much at all, because I didn't want a book that was Trump focused. It's really about what the modern presidency has become and how it's somewhat unmoored from the original presidency. And what do I mean by that? Well, if you look at the original presidency is principally a law executing institution, right? It's an executive. It has a check on legislation through a veto. It has a pardon authority. It has this authority to make treaties with the Senate's consent, and it has authority to make appointments. But its principal function is executive. I think if you look at the presidency today, it's been transformed. It's been transformed through practice. It's been transformed through reconception of the office. So let me describe the changes, and then let me describe how that's happened. Take war powers, the point of disagreement with John. So at the founding, Congress had the power to declare war. The power to declare war in the 18th century was the power not to just issue some document saying we declare war or I declare war against you, but the power to decide whether to wage war. And so it was the power to decide whether the nation as a whole would wage war. And that power was given to Congress. Now, how do we know it's not just this power to issue some piece of paper? Because in the 18th century, most declarations of war were issued via non-formal means, i.e. without a piece of paper. As the first British Prime Minister put it, most wars are declared of late from the mouths of cannons and not by some piece of paper. And so an attack on a foreign nation was the strongest form of a declaration of war, stronger still than some piece of paper. So when they gave this authority to Congress, they understood that Congress could only act through bicameralism presentment, which means that Congress has to pass a bill and then present it to the president. And if he vetoes it, they've got to override his veto to declare war. And this was said by many people before the Constitution. And importantly, it was said by the first president, right? If you read Washington's words as president, he says, I can't take the nation to war. I can't order offensive operations. And he's not the only person. You have Secretary of the Treasury, Alexander Hamilton, Secretary of State, Thomas Jefferson, James Madison, and Henry Knox, the Secretary of War, all saying this. And this is the consistent practice of the nation until the Korean War. Presidents do not take the nation to war without going to Congress. That's why you have a quasi-war authorized by Congress. That's why you have the War of 1812 authorized by Congress. That's why you have a war with Tripoli authorized by Congress. And that's why you have, as late as World War II, 5 separate declarations of war after the other nation had already declared war in the United States. So this is a situation where 5 Axis powers declared war in the United States, and then Congress responded. That radically changes in the Korean War. Harry Truman decides that he doesn't need to go to Congress, which is sort of remarkable given what transpired in World War II. his justification is we're not at war, we're in a police action. I think this confuses international law with domestic law. Whether or not the Korean police action is a war in international law, it doesn't matter. What matters is what our Constitution provides for those sorts of uses of force. And the answer was clear, that you had to go to Congress. Ever since then, presidents have relied upon their predecessors to justify their uses of force, right? And so Obama is able to say, Harry S. Truman did it, Bill Clinton did it, Ronald Reagan did it, and so I'm going to do it. And Trump's able to cite to all those experiences plus Obama in Libya. That's an example of a living constitutional approach to constitutional interpretation. We don't look at the founding, we look at what more recent presidents have done. Let me give another example in foreign affairs: treaties. The treaty clause says you need 2/3 of the Senate to consent to a treaty before the president can make it. That's a really high hurdle. But in modern times, presidents make treaties without getting the Senate's two-thirds consent. And again, they cite practice, right? One category of sole executive agreements has been expanded dramatically to allow presidents to make international deals without any congressional or Senate buy-in. And then another category has just been invented, the so-called Congressional Executive Agreement. What is that? Well, think of NAFTA. NAFTA is an international treaty that's ratified after the Congress passes legislation implementing it. So it's got some sort of democratic stamp, but there's no authority in the Constitution for Congress to give its advice and consent to the president's ratification of the NAFTA treaty, right? And this was done by Franklin Roosevelt as a means of making it easier to make international agreements. It's essentially read the treaty clause out of the Constitution. There are vanishingly few treaties made these days, which is in part a function of the fact that you don't need to go to the Senate to get 2/3 of their support if you can do it unilaterally by sole executive agreement, or if you can just get a majority in both chambers to approve the treaty. This is entirely an artifact of the 20th century. You don't see anything like this in the 19th and certainly in the 18th century. In fact, Washington denies that the House has any agency with respect to making treaties. And the final sort of radical change is I think the president no longer takes seriously the idea of a faithful execution duty. As you know, the Constitution says the president shall take care that the laws be faithfully executed. Modern presidents instead adopt approach of saying, look, I've got a policy agenda that I've made promises about while campaigning, and I will implement those policies by hook or by crook. They prefer that Congress legislatively enact their promises, but if they can't get it through Congress, they are willing to act unilaterally. So think of Obama's subsidy of the insurance companies that Congress refused to appropriate. Think of Obama's delay of insurance mandates for employers. Think of the financial bailout for auto companies pushed by the Bush and Obama administrations. Think of the wall that John mentioned. Donald Trump could not get more than $1 billion through Congress for his wall. The day that he got his $1 billion, he declared an emergency and took the act that John described, which is transfer funds from one account to another. He was relying upon statutory authority, as John says, but he was misusing the statute because there clearly was no emergency. Nothing happened from the time he reached his $1 billion deal with Nancy Pelosi and the time he transferred funds that constituted an emergency. He was basically reading that statute as if it said, whenever the president deems it necessary or useful to transfer funds, he can do so. That's not an emergency, right? That's not what the statute says. There are statutes that say the president can do whatever he thinks is needful or useful, but that isn't the statute that the president relied upon. How is he able to get away with this? Well, in part, he's able to get away with it because every modern president misuses these emergency statutes. They invoke them and continue to use that authority even long past any emergency, right? There are emergencies that have lasted for 3 decades, as if we're in a continuous state of emergency for the past 3 decades. So I think this is just sort of a common law of emergency that presidents have created by virtue of their acts. It doesn't comport with any sensible understanding of emergency. I don't think that Trump is really any different than his predecessors. He just happened to do it with respect to a particularly controversial act. but he's just doing what his predecessors have done in a more controversial area. So the presidency, I think, is radically different in these three respects. And one of the points of the book is there's no reason why the transmutation of the office won't continue. There's nothing about these changes that rendered them natural. If you went back to George Washington and asked him or James Madison, do you think one day people will read the Constitution as if the president had authority to declare war? I think he would be dumbstruck by the suggestion. And so whatever you think the president can't do now, the president can acquire over time, right, through dogged practice. And he can count on his co-partisans to support him when he is advancing their partisan agenda, right? So if Trump does something that seems amiss in service of the Republican agenda, the Republican base will defend him. If Barack Obama does something in favor of the Democratic agenda, even if it seems amiss to the rest of the country, the Democratic base will loyally defend him. And that is one of the means by which you acquire presidential power over time, new presidential power over time. And then I think, I list a bunch of other factors that sort of help the president. One is the rise of political parties, as I just alluded to. The presidents are the chiefs of their political parties and therefore can count upon the base's support when they advance the party's agenda, but they can also rely upon their co-partisans in Congress to defend them without regard to the institutional prerogatives of Congress. No Democrat complained about President Obama spending money without an appropriation. There were some Republicans who criticized President Trump for the wall spending, but that's likely because they disfavored the wall. If he had done something that was four square, part of the broad Republican platform, they would have been rather disinclined to oppose him. And so the rise of parties in American politics has meant a weakening of Congress because the president is the acknowledged leader of his party. Another sort of thing that I think that's contributed to the rise of presidential power, of course, is this idea of a living constitution. The title of the book is a play on imperial presidency. And one of the themes of the book is if a living constitution is such a good thing, why is a living presidency so bad? And it's basically a query to progressives who favor a mutating, changing constitution over time, but nonetheless oppose periodically a changing presidency. And my point is that you can't have it both ways. If Franklin Roosevelt was right to say we shouldn't be tethered to a horse and buggy conception of the Commerce Clause, then of course presidents aren't going to be tethered to a quill and cannon conception of executive power. They are going to update Article 2 in ways that advance their personal and policy interests. And that's what we've had. So, what's sauce for Congress, what's sauce for rights, a mutating, evolving constitution is going to be sauce for the presidency. And my final point is the presidency, a single president has far more influence over the shape of informal constitutional change than any other actor in the government, including Justice Kennedy. Because the president can act unilaterally and thereby seek to change executive power unilaterally. That's happened many different times. I've already sort of discussed that. But they also get to appoint new justices who will advance their conception. Think of Roosevelt, think of Reagan, think of Trump, right? They're appointing people who have a future influence on the trajectory of constitutional law. And they can also activate their bases as they enunciate new constitutional understandings, right? If Trump says something about the Constitution, he has a good portion of the country that are inclined to give him the benefit of the doubt as to that conception, especially, again, where it conduces to their policy platform. So I say that presidents are the 800-pound gorilla of the idea of a living constitution. And so if you favor that, you really are essentially favoring the outsized influence of one person on the scope of future constitutional change. So let me end by saying, I'm delighted to be here. And if the law school is changed to the Amy Barrett Law School, I will be delighted because that will mean that Judge Barrett made it to the court. And as the Silverman clerk, we think the world of her. Thanks so much.
Well, and thank you. And let me begin with an apology. I'm Dean Reuter. I was introduced before, but I didn't hear the introduction. And I guess I'm having some bandwidth problems here at my home office. So I apologize. I've never had this before, but I'm very pleased to be with you. And I welcome our two guests and authors. And I wanted to thank all the Notre Dame organizers. I do want to give John Yoo, Professor John Yoo, he's the author of Defender-in-Chief, a chance to respond to Sai Prakash, author of The Living Presidency. But John, as you replied to Sai, maybe you could talk a little bit more about whether or not everyone is conspiring to give the executive more power, and if so, why? Is it as Sai suggests because of the two-party system? So, and it seems to me that when it comes to the treaty power, declare war power, it's a form of delegation, like everything else Congress delegates to escape accountability. But is it that simple? Go ahead, Professor Yoo.
It's a great question, Dean, and it's, I think, a big difference between if you read the 18th century Constitution, the original Constitution, or even if you follow Sai's critique of that Constitution, or not the critique of the presidency. Sai's critique of the presidency is really what the presidency has become, not what it originally was. And what it's become is, I think it's much more due to Congress giving presidents powers than what the president has actually done with the provisions in Article 2 of the Constitution. Now, we could have debates about the war power, treaty power, and foreign relations. I tend to think that that's where the executive's nature as a unitary actor, right? There's only one person in charge of the entire branch who can act with speed and decisiveness and secrecy and energy, as it's described in the Federalist Papers, really comes to the fore as a national security and foreign affairs. And so I don't have the kind of problem Sai does with reading the Constitution to give a power that can grow to meet the times, because the founders thought foreign affairs and national security were so unpredictable, could not be written down and set within a boundary, because you can't predict all the threats that might occur to the country, what might not be necessary to protect it. I think that's the exact opposite of domestic affairs. And I think that's where people's worries about the president's constitutional powers are really coming from these days. But if you look at all the things that have been going on in our politics, Supreme Court appointments, the rioting and calling out potentially of law enforcement and federal military forces, and so on, that's all about delegated power from Congress. That's not the president saying, I have a constitutional power to send troops into the cities. This is a power that's given to the president under the Insurrection Act. This is a law that's passed in the 18th century and early 19th century. It's been used by many presidents. I think recently in California to stop the Rodney King riots in '92, or by Dwight Eisenhower to enforce Brown versus Board of Education in the South. But these are all done by laws passed by Congress. And so I think a lot of the concerns that Sai is raising are really about, has Congress given so much power to the president that the presidency is becoming unchecked? First, that's Congress's decision. As Dean suggests, people are conspiring to do it in the sense that Congress likes to give this power away. They don't want to make hard decisions. Those of you in political science, you're probably taught the thing that member of Congress want the most is to be reelected, right? Because they don't have tenure, the suckers, right? If they had tenure, they wouldn't worry so much about it, but they want to get reelected. You don't get reelected by making decisions on policy issues where 40% of the country is going to hate you no matter what you do. Delegate that to the executive branch agencies. And the president's happy to receive it because he gets blamed for it no matter what. Many people in the country now think the president's responsible for everything from crime to the economy, so education, housing. So why wouldn't the president at least want those powers that Congress wants to give up so that he can do things which the American people think he's responsible for already? I don't think that's a constitutional problem as much as a political problem. And I don't think one could fault Trump for making it worse. In fact, if anything, Trump potentially is making it better. He's someone unusual in presence in that he's been trying to deregulate. You may know I've read about this policy in the Trump White House that says for every new regulation that's issued, the agency has to repeal 3 existing ones. It's unusual for a president, and it's similar to foreign affairs. It's unusual for a president to try to actually restrict and narrow his own power. But I think that's what Trump's been doing. And I could see everyone saying, what's going to happen in Trump's second term if he wins re-election? I think it's a good question. But that could be the agenda for a second term, is further slimming down the government, reducing its influence in our everyday lives, and leaving more and more things up to the states. But again, as Dean suggested, this is like a political conspiracy almost more than a constitutional fault.
Professor Prakash, I want to give you a few minutes, but maybe you could talk a little bit about presidential power versus agency power, and the notion of the unitary executive, and whether or not that really is presidential power if the EPA is able to do X, Y, and Z to the regulated community. And also this distinction that Professor Yu makes between domestic and foreign powers. I'm wondering if in the era of globalization and the miniaturization of the world, even if you're not a globalist, you can get from one part of the world to another much more quickly. International commerce is more robust than ever, probably. Is the distinction between domestic and foreign powers sort of softening?
Well, as to the last question, Dean, I think, I think there's more commonality in foreign affairs and domestic than John does. But I agree that there are differences as well. So the way I think about foreign affairs is an executive power. John and I agree with that in the 18th century, the federative power, as Locke put it, is part of the executive power. And that when you read the Constitution, the question is, what parts of the federative power, the executive power, are stripped away from the president and given to Congress? And I think John agrees that the declare war power is given to Congress, whatever that is. He and I disagree as to what it is. The treaty power is checked by the Senate. The president doesn't have power to spend money in foreign affairs. He has to go to Congress. And so there are a bunch of checks on the president's executive power in foreign affairs. And our disagreements, I think, stem over how to make sense of those checks. I think it's true that, as Locke said, you can't have a statute that tells you exactly what to do in foreign affairs, right? The discretion is required in foreign affairs to a greater extent than in domestic affairs. And I don't think anything in the 20th or 21st century has proven Locke wrong. In fact, you might think it's proven him right. And so the court has long said that delegations in foreign affairs are more acceptable than delegations in the domestic context. And you certainly see, all sorts of delegations in the foreign context that perhaps don't exist as much in the domestic context. With respect to your first question, Dean, about the unitary executive, the unitary executive is this theory that the president is responsible for law execution and can direct executive officers as they go about executing statutes, and can remove them if he doesn't like what they're doing. And I think John and I agree that this is part of our Constitution. I agree that President Trump had authority to fire James Comey. It's not, it's President Clinton fired his FBI director. I think there's constitutional authority for that. I think the way to think of the EPA is that the EPA is part of the executive branch insofar as it's enforcing congressional statutes with respect to the environment. It's a little more tricky when Congress delegates legislative authority to make regulations. I don't know if the president can say that he has a constitutional right to control rulemaking. It so happens that he does control rulemaking, right? That with respect to executive branch agencies, at least, he exercises control, i.e. something like the cost-benefit analysis that OMB goes through. But it's not as if rulemaking itself is an executive power, right? If we were thinking about rulemaking in the abstract, it's just lawmaking, right? It's done by Congress. Congress chooses to delegate. And then the question is, does the president have some sort of constitutional authority over that? I think his claim over that is not as strong as his claim over prosecution, because that is a quintessential executive authority. And so it may well be that with respect to agencies, we actually have a deviation from the Constitution away from the presidency, because we have all these independent agencies that are in part enforcing the law without any presidential supervision and without direct presidential control. Think of the SEC, the Securities and Exchange Commission, the Federal Election Commission, Federal Communications Commission. All these alphabet agencies are basically prosecuting civil offenses with no, direct presidential control, and they're conceived of as independent agencies. I don't talk about that in the book, but that's one example where Congress has got the better of the president in a way I think that's inconsistent with the Constitution and in a way that the Supreme Court got wrong.
Well, Professor, you you mentioned that executive powers are probably at their peak during emergency situations and in war. If the president has the power to declare war, or at least execute a war without a declaration of war from Congress, and the power to declare an emergency, should that give one pause, especially if he's the guy that gets to declare when the emergency is over? And maybe cite as an example the idea that we have an authorization for the use of military force that is approaching 20 years of age.
It's a really tough question. I think one thing is, if you didn't have emergencies and wars, you might not need an executive. This is a fundamental decision the framers made, and that they thought about quite hard, because the other alternative, which most of our other peer countries in the world use, is a parliamentary system where there is no separation between the executive and the legislature. The prime minister is both the head of the executive branch and the head of the majority party in the parliament. And our framers rejected that idea. Actually, the first draft of the Constitution had Congress picking the president. And there's two reasons. One is there's a kind of efficiency or effectiveness reason. They thought that legislatures were slow. They thought legislatures dilly-dallied, that they couldn't make decisions. And so emergencies were were the ultimate example of that. And national security threats, war. Congress just is not good at coming together and taking action. Now, and the framers realized this too, sometimes the executive might make a mistake. In fact, it's maybe more likely one person will make a mistake than 535 people. But there are certain situations where it's more important to act quickly than to get it perfect. And I think that tends to be in national security and foreign affairs. That's what the founders thought. That's what John Locke, as Sai mentioned, thought. It goes all the way back to Machiavelli. I think the person who really started thinking about the executive power as a separate power. So I would say, yes, you could try to limit the emergencies. Congress could define emergencies in the National Emergencies Act. They could pass laws that would be tighter on a president and what they can do once there's an emergency granted. I think the last survey said there's 120 different laws that trigger if the president declares potentially trigger if the president declares a national emergency. You're seeing a lot of them on display right now during the pandemic, right? The Defense Production Act is not often used and not much thought about by civilians, but it's a vast power that comes into effect in national emergency and war that, as you can see, allows a president to take over industry. The problem, I think, Dean, in response to your question, in response to Sai, is if you start to try to list all the things that are emergencies, if you try to prepare for all of them in advance without giving the executive enough discretion to handle them, you are defeating the very purpose of having a presidency and having an independent executive.
I want to shift gears a little bit and maybe look at the relationship between the judiciary and the executive branch, and something that I think it's new, or I haven't really noticed it before, and that's the willingness of the judiciary to look behind executive actions to motives. And I'm thinking here, I suppose, of the DACA case, or the DUP case, and the census case, and some other examples where the Supreme Court seems to be looking at presidential motives or executive motives in their actions and using those motives to analyze whether or not the actions are legitimate. I'm going to give maybe Sai Prakash a chance to respond to that. Is that a new phenomenon? Have I characterized it correctly? Have I mischaracterized it?
I think it's relatively new, although I have to say, Dean, I haven't really researched the topic. And I think on this point, John and I might have different intuitions. My view is, if intent is relevant in understanding whether executive action is constitutional or consistent with statutes, then of course you're going to have to look at intent. And this isn't entirely novel, because when we think about Congress, certainly in the equal protection area, or the state legislatures in the equal protection area, we often are asking about the intent of the lawmaker. So, for instance, if a statute is facially neutral, it can still be challenged on equal protection grounds as, say, violating the Equal Protection Clause as being based on race animus if you can show a differential impact and that it was motivated in part by some racial animus. Well, if that's true for Congress or a state legislature, I'm not sure why it wouldn't be true for presidential actions, right? That is to say, if a federal act can be unconstitutional because it has a disparate impact and it was motivated by ill intentions, I don't know why an executive rulemaking challenged on equal protection grounds couldn't be similarly challenged. Having said all that, I don't know of a case where the court looks beyond the face of the executive order and then decides to impugn the executive's motives. If you look at the travel ban case, they recount everything that the president said, I think sort of tut, but then ultimately uphold it. And so it's an odd juxtaposition of looking at what the president said, I think disagreeing with the substance of what he said, but not letting that influence its analysis.
John, let me let you weigh in here, and then I want to, and you can in your answer if you want to, talk a little bit about something that seems to excite the conservative community, and that's a possible reinvigoration of the non-delegation doctrine and/or intervention by the court or change by the courts on deference, Chevron deference, Auer deference, Skidmore deference, what have you. Give us a prognostication on the second issue.
And I think a lot of conservatives feel that if there's a problem, it really rests with breaking this dynamic of Congress just ceding more and more powers to transferring more and more powers to the executive. My main argument is that it shouldn't be applied to foreign affairs where it has a particular need, and it's not really a political cop-out the way it is with domestic policy. You don't need the speed and decisiveness and energy of the executive for domestic policy as you do with foreign affairs. The problem is that the courts can't think of a test to police Congress. It's hard to say, well, if Congress gives the executive the power to pass tariffs or to retaliate against other countries or to put economic sanctions on people, what's the stopping point between that, which most people think is okay, and then things we won't allow? And so the Supreme Court has, thrown up its hands. There was a case in the early 2000s against the Clean Air Act, which basically says the EPA can set any standard to make the air safe and clean in the public interest. And the court said, well, that's enough to transfer all the power over the air from Congress to the executive branch. And there are several justices on the Supreme Court who say they want to re-examine this, but they haven't been able themselves to figure out what the test should be. And so that's part of maybe my political idea, is that maybe it'll be the presidents who have to limit it themselves. And maybe that's what we'll see, is like presidents who say, I'm not going to use all the powers that that Congress wants to give to me. And that maybe the American people want to start electing presidents maybe like Trump, who have a more modest vision of what the federal government should be doing in our daily lives.
I'm going to give Sai Prakash a chance to weigh in here, but then I think we'll turn to the students. I think Phil Munoz is going to moderate student questions, and I understand you guys know how to ask those questions. I know our experts know how to answer them. So, Professor Prakash.
I think Congress is to blame for delegating legislative power to the president. Presidents are to blame for signing all those laws into law, even though I think there's an implicit non-delegation doctrine into the Constitution. And the delegation of legislative power to the executive sort of feeds a vicious circle, right? Because presidents already conceive of themselves as policy innovators. They run on changing the law, changing policy. They then come into office and they have all this authority that's delegated by Congress. They have the Chevron doctrine, where there is no express delegation, but they are able to prevail nonetheless. And they see all this discretion and they naturally conclude, well, I have a pen and a phone, as Obama said, and I can do a lot unilaterally if I can't get it through Congress. And so it actually feeds the beast, the beast being the idea that the executive can do what it wants. And so it's not the only cause of I think our ills today, but it's partly a cause, and it exacerbates the tendency of the executive to use his unilateral authority to make or change policy. I think it's not the only problem, because I think presidents themselves are sometimes using authority that's not delegated. I don't think that the border situation is an emergency. And I don't think when presidents declare an emergency for 30 years straight under some statute that the 30th time is sensibly called an emergency, right? Because you could say the first time was. We'd have to go back and actually look at the situation. But after that, it just looks like the president's not going to Congress and asking them to codify their policy, or Congress is refusing to do so, or all sides are just relying upon this faux emergency to continue whatever policy some president inaugurated 30 years ago. And I gave you other examples of situations where presidents are just seizing authority. There was no delegation to the President Obama, to subsidize the insurance companies. The entire Congress opposed him, right? That was the whole point. They weren't going to give him the funding, and he did it anyway. It's hard to say that that's a delegation. And even our magnificent military, as big as it is, I don't view the existence of the military as an open invitation to the president to use it overseas. So delegation is part of the problem, but it's not the reason why we have presidents acting unilaterally in all sorts of ways that aren't traceable to law or the Constitution.
I suppose, though, it is consistent with the founders' vision that every branch of government will seize all the power it can, and so we can't, in that sense, we can't blame the executive, I suppose. But with that, let's turn to the students. Phil.
Gentlemen, we have a small group of students here in person at Notre Dame. Let me ask the room, any questions here in the room? Anyone want to ask a question? Sure, please.
Yeah, I guess.
Nice and loud.
Oh, sure. Thank you for coming and speaking. My name is Charlie. I'm a sophomore here at Notre Dame. But posed to both professors, I guess, how would you reconcile the need for a president to innovate and maybe sometimes expand his power or use the powers he's been delegated in new and creative ways with the idea of originalism?
Maybe
first, John?
Yeah, I think that's really Prakash Sai, I think, is in favor of a narrowed presidency because of originalism. I would say, and we actually share, Sai and I, very much the same starting points and approaches to interpret the Constitution. I think we're both originalists. As Sai mentioned, we even written articles together defending judicial review on originalist grounds, even though we had shared a room office together and really were sick of each other. So
that's not true, John.
Well, I was sick of you. So, and when it comes to executive power, it's similar, I think, to other clauses of the Constitution, in my view, where you could say that what the founders did is they didn't try to write a precise provision that was going to stay fixed in time, but they created a provision that was going to be able to change and adapt to the times. Now, I'm not saying sometimes, as people on the other side of this originalism debate say, that that's everything in the Constitution is actually like that. I think the Constitution has a mixture of some things were meant to be fixed, some things were allowed to change. For example, when the Fourth Amendment says, searches shall be reasonable, or when the Eighth Amendment says no cruel and unusual punishments, or the Fifth and 14th Amendments say due process. Those are terms which are rather open-ended, and I think the founders realized when you applied those to certain criminal procedures, they could change over time. I think the executive power is like that, because if you look at what the founders thought the executive power was, they defined it exactly in these phrases of it's this ability to act decisively and speedily with energy, and that it should be able to respond to circumstances which no one could foresee. So when you read descriptions like that, they say we shouldn't try to write it down and hem it in because we can't predict what those circumstances in the future will be. It seems to me the executive power is one that's seen as somewhat amorphous, can expand or contract depending on the circumstances. That's very different than the legislative power. If you look at Article 1, Section 8, it says the legislative power herein granted, and then it gives you a list of all the things the legislative power includes. And at the end, there's a provision that's, the 10th Amendment basically makes clear that you should be inferring new powers to Congress that didn't exist. So I think that and this is not my idea, right? This is the idea of Alexander Hamilton in the Helvidius Pacificus debates. He first really makes this argument. And then he says all the things in the Constitution, particularly in Article 2, which transfer things from the executive to Congress should be read as just exceptions to that general executive power in the president. Just because you say the Senate can give its advice and consent to the Supreme Court nominees doesn't mean the whole appointment of Supreme Court nominees is suddenly transformed into some joint executive legislative power. It's not. It's still executive, but a small part of it was transferred to the legislature. And I would approach all of the executive power that way.
Charlie, I think that's a great question. And John and I agree on first principles in terms of methodology. We also agree that the vesting clause is a grant of authorities not traceable to specific clauses in Article 2. So it's more than just what you find in Article 2. John has accurately quoted Hamilton, but Hamilton also said, right, that the president can't send money without an appropriation. The president can't wage war without a declaration of war. The president can't make a treaty without the Senate's consent. And the presidents are doing all those things. So I think where John and I disagree is the idea that the executive power, the meaning of it changes over time. John's actually saying that they intended some kind of living or changing conception of executive power. And I think instead they had a fixed conception of executive power. They qualified it in various respects by giving certain powers to Congress to be exercised through bicamerals and presentment, and then gave a Senate a check on appointments and treaties, but that everything else rests with the president and that it's fixed, right? It doesn't cover a power over some emergency, right? If you look at early emergencies, it's all done through statute. Presidents don't just say it's an emergency and I can do what is necessary, right? The militia is called forth pursuant to a statute, not pursuant to an emergency. And so, there have been emergencies throughout our history, and they've been handled, I think, for the most part, through presidents acting consistent with congressional authorization. One famous example where that's not true is Andrew Jackson's imposition of martial law in New Orleans at the end of the War of 1812. Andrew Jackson suspends habeas corpus and does all kinds of great things, and he is the hero of New Orleans, at least he was to older generations of Americans. But his president says you don't have authority to impose martial law or suspend habeas corpus. This can only be done by Congress. And his president was James Madison. So I have that conception of executive power. But great question, Charlie.
Okay, let me ask the students in the room. Any other student questions? Okay, for those watching online, I'll call you. Please use the raise hand function via Zoom. Our first question is by Kevin Brum. Kevin, I'm going to ask you to unmute yourself and then introduce yourself and go ahead and ask your question. Kevin?
Hello, my name is Kevin Brum. I'm a 1L at Notre Dame Law School. And my question is, we actually had another Federalist Society event where two professors were talking about the Supreme Court recently. And one of them, they were kind of both mentioning that Roberts has been more of he's had the sort of the status of the court in mind. At least that's what people hypothesize. And that maybe that's why the court doesn't really have these broad sort of landmark decisions that you saw, for example, from the Warren Court or something. And I'm just wondering, especially with the new Supreme Court vacancy and this talk that there's a need to sort of police Congress's delegation of power to the presidency. Do you think the court is, I don't know if timid is the right word, but maybe a little worried about straying into the sort of New Deal era court where they're striking down actions of the presidency and they gain the ire of Congress and the president to such an extent that it's looking like they are drawn into the public eye? Do you think that they're kind of worried about that?
I think the Constitution actually wasn't that different in practice until the New Deal. And as some of you may know, under the pressure of the Great Depression, Congress passes this vast expansion of federal power and massive delegation to the agencies. The court tried to stop it at first. Right? The Supreme Court actually struck down delegations then and struck down the early New Deal for going too far. And then FDR tried to pack the court. And conservatives, a lot of legal conservatives have always sort of said, let's try to pare back all the things that happened after then so that we can return more to the way the Constitution had been, I think, consistently applied up through the New Deal. You see that, for example, in Justice Thomas's argument about the Commerce Clause, which is for those of you who aren't law students, is really the great fountain of federal power in our country. Thomas wants to return it back to really things that cross interstate borders, for example. You see that in this desire for a non-delegation doctrine that Dean mentioned, this desire to say Congress can't keep giving away its own power to the agencies. I don't think that it's really a problem of Roberts and his trying to, it's more, I think, that conservatives on the court who want to do this have never had a working 5-vote majority. And this has been a problem going back to 1968. It's long before all of you were born. Republican presidents have had the vast majority of nominations to the Supreme Court since 1968. But whenever they get a 5th justice who's supposed to be conservative, that person always sort of starts drifting to the middle. And so I can go back all the way to names that you probably know from the history books, like Harry Blackmun or Lewis Powell or John Paul Stevens or David Souter or Justice O'Connor or Kennedy, all the way up to Roberts. There's a long, proud train of people who were unwilling to be the 5th vote to carry out that kind of revolutionary program. So it's not just Roberts, I think. It's a lot of justices have done that. Now, the thing that maybe the appointment of someone like an Amy Coney Barrett, I don't know, has she reached initial status? Is she called ACB at Notre Dame yet? So ACB, she would be this is something conservatives have never had, actually, which is 6 justices, which would eliminate the ability of this 5th justice to kind of play this moderating role in the middle. And this happened with the Warren Court and the liberal side, too. The Warren Court never really got going until they had more than 5 quite liberal justices on the court. So I would think if you got this seat filled in the next 2 months, then you might see something more aggressive, regardless of whether Roberts is the Chief Justice or not.
Kevin, that's a great question. I'd say that the chief is willing to push his agenda where he has long felt beliefs. So if you look at his race cases, he actually has said some very striking things, right, with respect to the use of race, even though that puts the court squarely within the line of fire of certain segments of the public. I think, on some of these issues, he doesn't have strong positions, and that's where he's most inclined to trim because he's worried about the court's position in society. I think if there's an area where it's easiest to try to get things right, it's the separation of powers. The public doesn't care about the non-delegation doctrine the way they care about abortion. The public doesn't care about non-delegation doctrine the way they care about affirmative action, right? They may care about, the products of delegation, like rules that are produced clean air and what have you. But remember, any regulation that is struck down by the court on the grounds that it results from an unconstitutional delegation of legislative power, Congress would be free under the Modern Commerce Clause to enact it tomorrow, right? It is a procedural constraint, not a substantive constraint on con law, right? To say that this regulation that's promulgated by this agency is constitutional, but it can't be done by the agency. So think about where the president, the Roberts has been willing to say that removal restrictions are unconstitutional, in part because no one besides people in this conversation care about that, right? The general public does not care about double for-cause protection or, about a single-headed agency, which was decided last year, the PCAOB, sorry, not the PCAOB, but the Consumer Product Financial Product Safety Commission, whatever it's called, right? They don't care about that, so it's easier for him to do what he thinks is right without regard to the public. And I think that's true for delegation, right? He can strike down statutes and then just say Congress can enact this tomorrow, and if they do, it'll be subject to the weak commerce clause.
I wonder if I can't use the moderators or co-moderators prerogative and get a question or two of my own in. This is, I guess, more for Professor Prakash, though. Professor, you please weigh in. Professor Prakash, other than people caring more about these things, what are the, is there one or two things that could be done to unravel or return to the original presidency as opposed to the living presidency? Or to come at that question a little bit differently, could the founders have done anything differently to forestall the emergence of the living presidency, in your opinion?
Well, those are great questions, Phil. As usual, you're a great interlocutor. I think the book has 13 suggestions for what Congress could do to push back on presidential power, involving, a range of things from war powers to staffing to a host of other things. And so I'm going to tease the readers by saying they need to go buy the book. It's got a bunch of different prescriptions. I think, in terms of, whether the founders could have done things, of course they could have, right? So, my understanding is that certain constitutions expressly say in a federal system what the states have exclusive authority over and what the feds have exclusive authority over. You can imagine similar things in Article 2, right? Article 2 could have had Article 2, Section 5, which said what the president could not do and not left it to implication. The Constitution doesn't expressly say that the president can't declare war. It is an implication of the grant to Congress. But if they had said that and they had said what a declaration of war was, it would be harder for the presidents to acquire the authority. So you can imagine a constitution that more carefully or more specifically hems in executive power in various ways. There is that to some extent, right? The take care clause is an attempt to say you should not be suspending or making law on your own. It hasn't entirely worked, right? In part because Congress has declared war and in part because presidents have adopted, I think, spurious interpretations of statutes. But yes, of course, the founders could have done any number of things that would have made it more obvious what the limits on presidential power are. But as you know, Phil, and as the students know, you can have a constitutional provision that says the government can't do something, and then society can choose to ignore it, right? Think of the Contracts Clause, right? It's basically been read out of the Constitution by legislatures and by courts that have acquiesced in its undue minimization. And so just having a parchment barrier is never enough. You need to be willing to stick to it and have institutions that are willing to stick to it. And so you could have, provisions in the Constitution that say 6 ways to Sunday, presidents can't start wars. But if no one is willing to say that the president can't do this, or if the presidents themselves aren't willing to stand up to that, it'll be to no avail. One final response to what you said, Phil. My view is that, John's story about the president defending the Constitution is great because it's a great title for his book. But I think in reality, presidents don't really care about expanding their office as much as they care about enacting their agenda. I think this president would sign any number of statutes that curb the presidency if he got money for his wall. His wall is more important to him than some abstract conception of the presidency, certainly with respect to war powers, because as John said, he doesn't want to start wars. And that's true for most presidents. They're not wedded to a particular conception of the presidency. They are wedded to their agenda. So it's actually quite, I think, possible to get bills on the president's desk that would restrain the presidency and simultaneously advance the president's policy agenda. And I don't think presidents would bat an eye. I think they would sign that in a heartbeat. Certainly the president who authored The Art of a Deal, or partly authored The Art of a Deal, would be willing to make a deal.
Professor Yu, we should allow you to respond to that.
I disagree with Sai on that last point, which is, and maybe it does go to your original point, what would you do differently if you're at the founding and you're writing the executive branch portion of the Constitution, it's the founders didn't expect or need the president to worry or think about the Constitution that much. You know, President Trump, they got their wish, right? What they needed was somebody who would pursue their interests, right? The founders said, I think, quite clearly, they expected the executive and the legislative branches to pursue their interests. And it's by fighting between themselves that they check each other and that individual liberty is protected by making sure the government as a whole stays within its boundaries. That doesn't require President Trump to be thinking about the Constitution all the time or all that much. What it requires him to do is to pursue his interests and the executive branch's interest. The thing I think that failed in that system was that it's Congress that's been, I think through our discussion, we see this clearly, it's Congress that's been giving up its powers, that hasn't been fighting with the executive that much. They do on political things, but on constitutional matters, they don't. And so if you were going to write something, I think maybe into the Constitution that's not there, it would probably be something more about increasing the president's control over executive agencies, but also limiting what Congress is able to give up. In other words, making Congress take more votes on more important policies rather than giving them up to independent agencies.
I wonder if I might just, we're just about out of time, but I wonder if I might just push back a little bit on Sai's comment, and maybe actually to some extent, John, on your comment too. Would presidents be more concerned about the Constitution and their own constitutional powers if there wasn't the two-term limit?
I think you're right, Phil. I think they would be. But as I say in the book, you know, I don't think they're intrinsically interested in presidential power because they're very focused on the short term. They're focused on their agenda. If they could predict with, certainty that their kids would be president, they might want to give a stronger office to posterity. I think, to circle back to what John said, I think John's accurately describing this president. I don't think that he's deeply engaged in the Constitution, and that's probably true of many of our more recent presidents. They have lawyers that do that for them. But if you read the Constitution and you think about the title of John's book, the president takes an oath to preserve, protect, and defend the Constitution. That's the only oath specified in the Constitution. The language of it specified. And early presidents took that quite seriously. They vetoed bills if they contained unconstitutional provisions, full stop. Whereas today, presidents will sign those bills and then just refuse to enforce the portions that are unconstitutional. So I think John's wrong that I think they really did expect presidents to engage with the Constitution in a way that we might think is implausible given, our modern circumstances. But I actually think in this point, the Constitution text actually suggests that John's wrong.
Yeah, I disagree with you as usual. But it's just if you read the Federalist Papers, they don't have a lot of faith in what they call parchment barriers. They don't really expect judges to get involved here. They don't talk a lot about judicial review as being the arbiter between the executive and legislative branches. What they really wanted is the executive and legislative branches to fight all the time, and that is really the mechanism. It goes beyond sort of the idea of sort of lawyerly writing out exactly what each branch should do. It's really expecting them to gather their constitutional powers and using them to fight each other politically.
Gentlemen, thank you very much. Dean Reuter, John Yu, Sai Prakash. Because we missed Dean Reuter's introduction, we didn't get the title of the books that have been referred to. Sai Prakash's book is called The Living Presidency, an original argument against his ever-expanding powers. And then John Yu has recently published Defender-in-Chief, Donald Trump's Fight for Presidential Power. Both those books published this year. Gentlemen, thank you very much. And thank you to all who watched us online. And thank you especially to the students who joined us here in person. Thank you.
Thank you, guys.